today I'm going to be talking to you about Magna Carta and the letters patent. And folks, they're handing out right now some documents for you folks. One document has the motto or the logo of the crown on it, and it says Magna Carta 1297. Those three sections of the Magna Carta are still alive and well and living in the United Kingdom. In other words, the document that was created in 1215 is alive and well and living in Canada under the preamble of the British North America Act. It is part and parcel of your rights. Now, when it comes to letters patent, this is fun because Magna Carta is letters patent. The Royal Proclamation of 1763 is letters patent. The Dominion of Canada could not be created without letters patent, and there would be no province of Ontario without letters patent. And if you read the Boundaries Act of 1858, the boundaries between Quebec and Ontario actually reside and are stated on individual private property owners' patents in certain areas. So if the patents don't mean anything, as some people say they don't mean anything, well, then I would say that the Dominion of Canada does not exist. I would say the province of Ontario does not exist. I would say your local municipality does not exist because it's also created on letters patent. The Governor General would not exist without letters patent. And not only that, just recently, in 2013, the Métis case versus the the Attorney General of Canada in regards to their letters patent not being issued under the 1870 Act. Under Section 31, the Supreme Court of Canada stated that the federal government had failed to honor the Crown by not issuing the letters patent to the Métis under the 1870 Act. That's 2013, people. Now, the only difference between the patents that we have for our private property and, say, the treaties is you guys don't believe in the letters patent. The natives believe in their treaties. And it's up to us as Canadians to start upholding our contracts with the Crown the same way the natives do with their contracts with the Crown. Because that is what your letters patent are. Now, there are different types of letters patent. There are the letters patent which created Magna Carta, the Royal Proclamation, the Dominion of Canada, Trudeau's 1982 document. I have the letters patent that came with it. Those are one type of letters patent. Your letters patent involve the prerogative and the honor of the Crown. Now, there's a book out there, and don't laugh at this guy's name. His name is Chitty. And in Chitty, he wrote a book on the prerogative of the Crown. And it is always to the favor of the patentee or the grantee against the Crown. If you need proof of that, 1994 Roundtree Beach Association versus the Attorney General of Ontario, where reading the document in its entirety is not going to change what the statements were or the intent of that document. And the intent of the letters patent for the settlers was to actually conquer this country, because there is only 4 ways you can conquer a country. And settlement happens to be one of them. That's what the Crown wanted to do. And that's why it was such a really great deal getting your letters patent. This is why people came from England. This is why the Americans who were loyal to the British came up here and fought against the Americans in 1812. Because they knew that they were going to be on the same footing as the Crown and the rich land barons. That was the whole reason. These are your private property rights. That's why they're so important. And as for Magna Carta, there is not just one Magna Carta. Magna Carta was reconfirmed. Actually, in 1217, they took out sections 44, 47, 48, and 53. And they created what was called the Forest Charter. And under the Forest Charter, if you're looking at Endangered Species Act, if you're looking at the Conservation Authorities Act, if you're looking at any of these acts that are restricting or regulating you on your private property, all you have to do is look at Magna Carta and the Forest Charter to realize that any of those pieces of legislation are completely unconstitutional. And they know it. If you have varmint on your property, one of two things can happen. If it is doing damage to your property, you have the right to kill it. As it was with the two gravel pit guys up near Muskoka, there was supposed to be, I got to tell you about, okay, the two snakes and the turtle story in the gravel pit. So there's these two gravel pits. One's on this side of the road, one's on the other side of the road. This guy has his letters patent, this guy does not. Ministry of Natural Resources says, you guys have two snakes and a turtle, and they're endangered, and we're going to protect them. And if you don't let us protect them, well, we're going to charge you. The guy with his letters patent told the M&R to go pound salt. The guy on the other side of the road, though, oh, well, we better sign on the dotted line. And he signed on the dotted line. So now he has to have a staff member who is completely educated in these endangered species. And by the way, it was a turtle, and it was a hog-nosed snake and a rattlesnake. So this employee has to ensure that during mating season, there is no work around where the habitat for these two snakes and the turtle are. They have to make sure that they have snake-proof fencing up. They have to ensure that, anyone that comes onto that property is fully informed that they have endangered species on their property. And this employer has to shut down at certain times when it's the sensitive mating season for two snakes and a turtle. The other guy across the road, he's not too worried about the two snakes and the turtle because M&R is leaving him alone. Because he said, I have my letters patent, leave me alone. If you don't want me looking after the two snakes and the turtle the way I have all this time, then get your two snakes and your turtle off my property. It's all covered. That's why Magna Carta is your rights. Trudeau's charter is not worth the paper it's written on. If you want to uphold your rights, if you really and truly want all of your rights, and I'm not talking just your property rights, I'm talking your freedom of speech, your freedom of religion, your ability to actually walk tall and hold your head high, you will be supporting the British North America Act and your common law rights. Because in Ontario and in Canada, the only law that is to be between the people and the government is the common law. Mercer, 1881. And that's what we have to do. Trudeau's charter has two sections in that document that remove your right to life, limb, liberty, freedom of speech. But you notice there's no property in it? We have property rights in Canada. They are protected under the preamble of the British North America Act. They are protected by Magna Carta. They are protected by the Petition of Right from 1623. They are protected by the Bill of Rights from 1689. They are protected by the Statute of Monopolies from 1623. They are protected. It's up to you to do the work to protect them. We have all kinds of information. And Magna Carta still stands as of 2005 because the judges seem to like Magna Carta to support them. They've used it time and again to support who they are. They have used it, actually 2005, they used it to support the fact that judges are the ones that determine the sentencing. The government cannot legislate that because it's covered under common law. Back to Magna Carta. Just this past year, the provincial government is involved as an intervener in a language case, trying to prove that English is the law in the courts other than Quebec. Now, a lot of people say I use a lot of old documents. The province of Ontario is using Magna Carta from 1225 and the Language Act from 1731. I'm thinking the British North America Act's a little newer. And if you look at the Property and Civil Rights Act in the province of Ontario, which by the way is one paragraph, it will refer you to the Constitution of 1792. When you get that book, because that Constitution is a huge book, if you go to Chapter 81, subsection 9, you will see that any law that has been passed or shall be passed cannot and is not applicable to patented land. And when you are looking at your British North America Act, you look at Section 109 where it states the lands, mines, minerals, and royalties of the province at the time of union subject to any trusts or any interests not of the province in the same. That's almost word for word. What that means is those trusts and those interests not of the province in the same, those are your rights. The Queen in right of Ontario has no right, title, or interest in or to your private property. They removed the Crown domain with the letters patent. If the Crown has no jurisdiction, the province doesn't have any jurisdiction. The Dominion of Canada has no jurisdiction. The municipalities do not have jurisdiction because all power for those entities comes from the Crown. And the Crown can't grant two people the same interests in the same thing. And that's the letters patent. Now, Magna Carta. This is fun. So in 1066, this guy named William decided he was going to invade England. He was a nasty, nasty, nasty guy. Anyways, he succeeded in invading, kicked the living bejesus out of the British, took their land and everything else, and any guys that he killed off, he made their widows marry his guys. So he decided in 1085 he wanted to have a list of all of the properties in England. So he created what was called a census, and actually it was called the Doomsday Book. Yeah, great name, eh? Doomsday Book, and it was. But then in 1087, he wanted to really push the envelope. He wanted these barons, the rich guys that owned the land and the ones that got to marry the rich widows, he really wanted to push them to the point that they would just knuckle under him. So in 1087, he brought all of the landowners to a place called Salisbury. And he made them swear an oath of allegiance to him. There's one problem with that oath. It never created feudal law. Everybody thinks it did. It became a custom to think that it created feudal law. How do I know this? I have this really neat history book at home. But they all believed that they had sworn an oath of allegiance and that it created the feudal tenures and the feudal law. And this went on until about 1212. I have an essay on the Civil War that started. Because he got to the point that no one was allowed to have any weapons to defend themselves. No one was allowed to hunt any of the king's animals. It didn't matter if you were starving. Punishment for killing a rabbit with King John, actually the successor of William the Conqueror. I think there was William, Stephen, somebody else, and John. If you killed a rabbit, you would lose an eye. He wanted to make sure that the people were in as bad and poor condition as he possibly could. So he protected all of his wild animals. Any open areas at all became crown forests. He started taxing the barons like 90. Well, he should have just left it at picking on the poor people, because when you start picking on the rich people, they got the money to fight back. So, yeah, it sounds exactly like today, doesn't it? It is today. We are merely repeating history all over again. But the whole thing is, these rich barons got together and they got all their guys together. And they had a heck of a civil war. And they whooped King John's butt in Runnymede. And they made him sign Magna Carta. Now, Magna Carta is not exactly what you think it is. Magna Carta had 63 different sections in it. And it kind of just laid it all out, what were the rights, what were the rights kind of thing. Like Section 1, which is still Section 1 today. Freedom of religion, and that the Church of England will be free. And actually Section 9 in here was actually Section 13 in the 1215 Act. That all the municipalities, including the City of London, would have their free liberties and customs. Which means when we go to municipal council and they say, well, the province is telling us to do that, wrong answer. They have the authority to stand up to the province. And the last one, Section 39 of this document, is actually included in the 1897 Rights of the People Act, which still stands in the province of Ontario today. And no man will be destroyed. That means no man's wealth will be taken. Unless, of course, it is by the law of the land, which is common law in this province and in this country. But it's up to us to start upholding our rights. Back to Magna Carta 1215. The reason that document is so important is it takes us back pre-1066 to the Anglo-Saxon common law, which was the customs of the land. In some areas, something would be legal. In other areas, that same thing would not be. That's why you had the county courts. You would have, how did it all work? You would have a kingdom, and that's the other thing too. There wasn't just one kingdom in England. There were 5 large kingdoms. There was Wessex and Essex and Nottingham, I think, and 2 others. And each one of their kings was actually elected. What we don't understand is Queen Elizabeth, her son Charles doesn't necessarily have to be king. William doesn't have to be king. If we don't like what that king or queen is doing, we can remove them. They've done it throughout history. Mind you, I don't want to cut off Elizabeth's head like they did to Charles I. He was another one of those nasty kings. That's the time of Oliver Cromwell. They created, the British Commonwealth was actually a republic in the 1640s to the, 1650s, 1670s? William Cromwell passed the act, and it is called the Agreement of the People, and it's from 1649. And it limits our parliamentarians because the deal has been done, and that deal was they would uphold our Magna Carta rights, which are our common law rights. Your inalienable rights are covered under that, and they are life, limb, liberty, freedom of speech, freedom of religion, private property, and freedom of contract. Who in this room deals with the Drainage Act? Well, I know you do, Terry. Farmers, do you not deal with the Drainage Act? Do you not have deals between yourself and your neighbor? If you read the Drainage Act, in the legislation now, they're trying to interfere. Because if you enter into a contract with your neighbor in regards to a drain between the two of you, they want you to include the Drainage Act in that contract, in that deal. You don't have to. Because that's interference in a two-party contract. Now, I'm not a lawyer. I'm not giving legal advice. I'm telling you what the research tells you.